Welcome back to How to Fabricate a Murder. I've got Tal with me here again, and today we'll be diving into what might be the most disturbing detail of this case, the wet spot issue. Before we get into it, I want to note that ABC Investigative News covered this issue in 2023. This was an important step forward. It drew some public attention to the problem, but it didn't go far enough. The reality is, the full story is much darker, more calculated, and more manipulative than they let on. And this added complexity is exactly what makes it so damaging. So let's start with this. The prosecution, the defense, and the judge all told the jury that there was no direct evidence in this case. That means that the case was fully reliant on circumstantial evidence. Here's my dad's attorney, Seth Zuckerman, to explain the issue. So, Seth, can you explain the legal meaning of circumstantial evidence?
Sure. So circumstantial evidence is direct evidence of one fact that could lead to an inference of another fact. Meaning, direct evidence is when you see, hear a fact. Circumstantial evidence is where you take that fact that you see or heard and you then infer another fact. So the way the New York courts generally define it is they use an example of whether or not it was raining outside. So obviously if you're outside and you see the rain, that's direct evidence that it was raining outside. But if you're inside and you see someone come in with an umbrella that's soaking wet, or you see their clothes is soaking wet, that is an inference that one could make that it is raining outside. Even though they didn't directly see or hear the rain, they inferred it based on the facts that they saw themselves.
During the trial, Matthew Bogdanos told the jury, and I quote, "You look at the other photos, you'll see, much later, it's dry." Here's the photo that he displayed while saying this. This photo was taken at 2:17 in the afternoon and shows a dry bed. His statement is misleading because it implies that there were pictures taken earlier in the day. However, this is impossible because the crime scene photographer only arrived at around 2 p.m. that day. Nobody contested the dryness of the bed. It is very clear that the bed is dry. Then he showed this second photo. 3 attorneys were sitting at my dad's defense table, including Seth, and all of them believed that this was a separate photo. In fact, Seth even attested to that belief in a 440 motion. The people protest that Mr. Covlin's claim that this photo was not admitted into evidence is false because it was in fact nothing more than an enlarged portion of a different photo that had been admitted. They explicitly presented it as a different photo completely. My dad and his attorneys had no idea what was coming. Bogdanos told his assistant to zoom in. Here are his exact words. "Let's blow it up, please. Let's keep blowing it up. Let's keep blowing it up." This is what it looked like when he stopped blowing it up. Just to be clear, this isn't him instructing his assistant to blow up the original image. This is him instructing his assistant to blow up an already magnified image. When he was done, that dark spot took up about 2 feet on the projector screen. Then he claimed that this dark area was a wet spot. Here's what he said. "What is that? What's that wet stain? Why is it wet right here on the bed?" He said this magnified image had been taken in the morning. But here's the thing. No photos were taken until around 2:10 p.m., as we already established. This photo was the basis for his claim that my dad cleaned up the blood with seltzer after attacking my mom.
So your dad wasn't just a killer, he was also what? Like a miracle janitor? So dab a little bit of seltzer and poof, all the blood is gone? Might as well give the guy a cleaning contract, eh?
Right, I mean, that's not even how blood works, right? Seltzer would only dilute it. And beyond that, that was on my dad's side of the bed. That's where my sister and I were sleeping that night. And even months later, when the police finally got a search warrant, no one collected the sheet, no one tested it for blood. And that second photo isn't even a second photo at all. It's just a blown up portion of the same photo Bogdanos had shown moments earlier.
That can't be right. So you're telling me they used the same picture? And no one noticed? How do you even know this for sure?
Well, no one did know for sure. So my dad's appellate attorney sent a request to the DA's office to clarify the matter. Here's an email from the DA's office showing that it was the same photo, months after the trial ended. I can confirm for you that the photo appearing on page 143 of the PowerPoint that we sent you is People's Exhibit 262. And during deliberations, the jury asked for just 6 things. One of those was the, quote, wet spot photo. This shows that Bogdanos really got the jury to believe that there was a wet spot. That one request proves just how deeply the prosecution's lies influenced the jury's decision-making. They deliberated with fake evidence in mind. And that should disturb everyone listening. He fabricated the only evidence placing my father at the scene of the crime. And it just didn't exist. Alright, Seth, you've heard all of this. Is it accurate? So, Seth, do you believe that the jury really believed that there was a wet spot at the scene of the crime? And do you believe that that impacted their decision?
I do. So during deliberations, the jury sent out a note in which they requested to see a photo of the master bedroom fitted sheet, and then in parentheses they wrote rip/wet stain, end parentheses, introduced in summations. So they wanted to see the photo that the prosecution had claimed had the wet spot that they for the first time saw in summations. So they saw that photo based on the prosecutor's argument that there was a wet spot. And obviously, in convicting Rod, they must have believed the prosecutor's theory that there had been a wet spot on the bed in the morning, despite the fact that the prosecutor has later admitted that there were no photographs of the bed that morning, and that when the detective Brown from crime scene took photographs that afternoon, he testified that there had not been a wet spot on the bed.
Even this one issue is such a glaringly clear example of prosecutorial misconduct that every single one of my father's attorneys believed that this issue alone should warrant him getting a reversal. He fabricated the only piece of evidence placing my dad at the scene of the crime. That's a violation of due process, a constitutional right. Here's Seth to explain due process, prosecutorial misconduct, and why this issue alone should have warranted my dad getting a new trial. Alright, Seth, can you please explain due process and prosecutorial misconduct relating to the fabrication of evidence and whether or not that might warrant a new trial?
Obviously, the Constitution guarantees everyone the right to a fair trial. It is a bedrock principle of our country, and everyone is entitled to due process. Prosecutorial misconduct arises when something out of the ordinary that's improper happens by the prosecutor. They obviously have a duty of fairness and fair dealing, and they have an obligation as a sworn officer of the state to conduct things fairly. Defendants are entitled to a new trial if prosecutorial misconduct rises to the level of the defendant being denied their right to a fair trial, which then, in essence, violated their due process rights under the Constitution.
Even after the trial, when my dad's appellate attorneys were reviewing the photos, they weren't sure if those two photos were one and the same. So Stephen Feynman, an appellate attorney with 35 years of experience, sent the following email to the DA's office. Is the photograph that was admitted into evidence as People's Exhibit 262 the same photograph that Mr. Bogdanos was referring to on page 4583 of the transcript? So again, here's a confirmation that the wet spot photo and the dry bed photo taken at 2:17 p.m. are the same. I can confirm for you that the photo appearing on page 143 of the PowerPoint that we sent you is People's Exhibit 262. And that was from ADA Susan Glinner from the Manhattan DA's office. What happened next? My dad's attorneys raised this issue on appeal, and the prosecution finally gave an answer. Bogdanos simply misspoke. I've thought a lot about this, and I truly believe that it's impossible that he simply misspoke. First, he knew the crime scene photographer didn't arrive and start until after 2:10 p.m. Bogdanos knows how this works. He's been a prosecutor for 30 years. Second, if he already said that the bed was dry at 2:17 p.m., he had to tell the jury that it was wet earlier in order to make the wet spot story make sense. There's no other way to get from wet to dry except implying that it dried.
So basically, he needed a wet bed that dried. But there was no wet bed, so he just said one existed? Or could it be wet and dry at the same time? And we could call it Schrodinger's bed.
Yeah, that's pretty funny, Tal. But no, you're exactly right. And again, this wasn't just some throwaway detail, right? The jury asked for this during deliberations. They were thinking about it. It impacted their decision. The appellate court could have ruled on it, but they said that it had to be brought up in a 440 motion because the issue wasn't preserved. The issue not being preserved just means that my dad's attorneys didn't object to it at trial. So that's what they did. My dad's attorneys filed a 440 motion. Section 440.10, Motion to Vacate Judgment. Here are the relevant grounds. B. The judgment was procured by duress, misrepresentation, or fraud. C. Material evidence was false and known by the prosecutor to be false. So either Bogdanos knew the wet spot was fake or he didn't. If he did know, then my dad gets a reversal under Section C of the 440. If he didn't know, then my dad gets a reversal under Section B of the 440 because false evidence still influenced the jury's decision. Either way, my dad gets a reversal. But the judge denied the motion. She accepted the prosecutor's claim that everyone knew the dry bed photo and the wet spot photo were the same. Here's exactly what she said. The assertion that the prosecutor used a photograph not in evidence is concerning. Notably, Mr. Zuckerman was present when People's Exhibit 262 was enlarged. Again, the judge goes with Bogdanos despite Seth Zuckerman attesting that he and everyone else were misled. So here's a conversation I had with Seth about this. Okay, Seth, were you aware at the time of the trial that the photo was not submitted into evidence and had been manipulated?
So we did not know that. We did not know where that photograph had come from. We had not seen that photograph before. And we were shocked, and we didn't learn it until after the trial that that photograph was A, not in evidence, and B, had been blown up to the proportion to the fact that the prosecutor was able to argue that there was a wet spot despite it clearly being a shadow and despite all of the evidence to the contrary, which said that the bed was not wet that morning, and which is why the prosecutor's theory that the wet spot had occurred in the morning, which they now later admit to the fact that they misspoke, is just clearly not true.
Bogdanos didn't say that the wet spot photo was already zoomed in. In fact, it only took up about 4% of the original dry bed photo. Nobody could recognize it. He misled the jury and the court. And in the ABC segment, remember, not one first responder noticed a wet spot. There were 15 of them, including detectives.
So why didn't your dad's attorneys object to this at the trial?
That's a good question. There were 3 experienced trial attorneys at the table, but Bogdanos was careful. He showed the dry bed photo early in his closing, on slide 72, and the wet spot photo about 2 hours later on slide 143. His closing went on for 6 hours across 2 days, and he never called the wet spot photo People's Exhibit 262. My dad and his lawyer felt that something was off, but you can't object based on a vague feeling you have. You need a specific reason. Matthew Bogdanos fooled everybody. He planned it that way, and he used his 30 years of experience to do it. That answers the wet spot question, and it also explains why they didn't object to other things, like the supposed blood splatter on my mom's legs. But we'll cover that in the next episode.
So, I know we're almost done here, but it really bothers me that this is the only thing linking your father to the scene of the crime.
Well, there is also the blood splatter claim, but that doesn't link him to the scene in quite the same way.
So basically what you're telling me is that they used 2 pieces of fake evidence to convict him?
Yep, that is what I'm saying, and we'll get into that next thing soon.
Right, but I know your dad said he believed in the justice system, and this just, quite frankly, doesn't feel like justice at all.
Yeah, it doesn't seem like justice to me either. And just so you know, all the documents used in this episode and all other episodes will be on our website, murderfab.com. We'll link that below in the description. This is the first time anyone has publicly spoken out against this issue in such detail. I stand behind every word. If anything I've said is not true, or Bogdanos thinks I've libeled him, I invite him to sue me. But he won't. He can't. Because the truth is the best defense to libel. And, unlike fabricated evidence, you don't need a zoom button to tell the truth. If you find Bogdanos' actions outlined in this episode to be disturbing, and you want to help, there will be resources on the website, murderfab.com. Thanks for listening to How to Fabricate a Murder. We'll see you soon.